So we'll call the House Impeachment Committee to order. Would our clerk please call the roll?
Representative Burke.
Present.
Representative Decker.
Present.
Representative King.
Present.
Representative Kulkarni.
Present.
Representative Miles.
Here.
Representative Nemes. Chair Elliott.
I'm here. So our second item is the adoption of the minutes from the previous meeting last week. Is there a motion to approve the minutes? Motion by Representative Decker. Is there a second?
Second.
Second by Representative Burke. All those in favor, please say aye. Aye. Those opposed, no. And the minutes are approved. So this morning we're pleased to have with us three Commonwealth's attorneys from across the state. The Honorable Brian Wright, who is the Commonwealth's attorney for the 29th Judicial Circuit and a constituent of mine. I'm glad to see him here and thank him for his service. The Honorable Rob Sanders, Commonwealth's attorney for the 16th Judicial Circuit, and the Honorable Jackie Steele, Commonwealth's attorney for the 27th Judicial Circuit. If you three would come forward, please, to the table. So if each of you would raise your right hands, do you solemnly swear or affirm that the testimony you're about to give in the matter of the impeachment of Ronnie Goldie shall be the truth, the whole truth, and nothing but the truth? Thank you so much. If each of you would introduce yourselves for the record, and then I think it'd be appropriate for each of you to give an opening statement about your background, your time as a Commonwealth attorney, and familiarize yourself with the committee a little bit if you're willing to do that, and I'll let whomever start who wants to.
Good morning, Mr. Chairman. My name's Rob Sanders. I'm the Commonwealth's attorney for the 16th Judicial Circuit of Kentucky, which is Kenton County. I have been the Commonwealth's attorney since my election in 2006, took office January of 2007. Kenton County in the 16th Circuit is Kentucky's third largest circuit by population. We are the second busiest circuit by indictment numbers. For those of you not familiar with Kenton County, we're right across the river from Cincinnati, Ohio. So we are a major metropolitan area that gets real rural real fast as you head south of I-275.
Good morning, Chairman Elliott. I appreciate the opportunity to be here. I'm Brian Wright. I'm Commonwealth's attorney for the 29th Judicial Circuit, which includes Adair and Casey counties. I started prosecuting in 1998 as an assistant Commonwealth's attorney, became Commonwealth's attorney elected in 2002, spent about a little over 3.5 years or so in private practice from 13 to early 17, and resumed as Commonwealth's attorney in March of 17 by appointment. So I've now spent about 20 years as a felony prosecutor in Casey and Adair County. I've been a special prosecutor in several counties throughout the state. We are more of a rural district, as Chairman Elliott is very familiar with our area of the state, but deal with all sorts of crimes, everything from drug crimes that everybody deals with to homicides and everything in between. So honored to be here. Unfortunate circumstances, but happy to come at the invitation of Chairman Elliott. Thank you.
Good morning, Chairman. Thank you again for having us here this morning. My name is Jackie Steele. I'm the Commonwealth attorney for the 27th Judicial Circuit, which is Laurel and Knox County, Kentucky. And to give you some reference, I'm about an hour south of Lexington, right on I-75, which is Laurel County. Knox County is just off to the side of that. I'm about 35 miles north of the Tennessee line on I-75. I would consider myself a rural jurisdiction also, about 100,000 people between both those counties. Not as rural as Brian is, but definitely not as metropolitan as Rob is in Kenton County. I've been a prosecutor since April 1st, 2003 as an assistant Commonwealth attorney. I became the Commonwealth attorney by appointment by Governor Beshear in June of 2008. I've been the elected Commonwealth attorney since that time. So I'm just literally a couple of days less than 2 months away from my 20 years as a felony prosecutor in the Commonwealth of Kentucky. Thanks for having us.
Mr. Chairman, I think it's worth noting as well that the three of us are also 3 of the 5 elected members, or Commonwealth attorney representatives of the Prosecutors Advisory Council currently, and that at one point or another, each one of us has served as president of the Commonwealth Attorneys Association and I currently serve as the co-chairman of our legislative committee on the Commonwealth Attorneys Association, and Brian is our immediate past president.
Well, thank you very much, and I know, gentlemen, staff has sent to you some documents, the resolution that was filed for impeachment against Mr. Goldie, the response that he submitted to our committee. And so you've had an opportunity, obviously, to review that as well as the order of adopting the report of the special commissioner temporarily suspending Mr. Goldie as well. I guess I would ask generally some observations that you would have based upon the review of those materials directed to Mr. Goldie. If you want to speak, obviously, hypothetically, that's fine as well. As to just some general observations of what you determined from your review of those materials. And I know that's very open-ended and very broad, but I wanted to start broad before I got narrow, I guess.
I'll start, Chairman Elliott. You know, we like a lot of people had read the excerpts that were published in the local in the statewide newspapers. Some of the news coverage that this had generated a few months, maybe 9 months or a year ago. We were aware of some of that, but we had not seen the entirety of the messages that this committee shared with us prior to today. And I think, initial observations, and we haven't had an opportunity to independently investigate any of these things. So we're taking them, I guess, for the most part, at face value for what they are in the context of the messages and his response and the resolution, of course. But I think the first thing that jumped out would be the amount of contact with what appeared to be a defendant represented at least most of the time by counsel through extrajudicial means outside of the courtroom, outside of the context of the actual case, but having conversation about criminal matters, having conversation about personal matters, having conversation about things that were going on in court, contact with judges, contact with other attorneys on the person's behalf, that seems to be outside the bounds of what we as prosecutors normally engage in on a day-to-day practice in prosecuting cases. That's what jumped out at me at first, if I can be very general and broad.
If I may follow up to that, I agree with Brian, but let me say this, and we, as the Commonwealth Attorney Association, have very limited power. And when we found out about these allegations, we were actually in the process of amending our rules and constitution so that we could expel members for conduct like this. And there was another member that we had been aware of for some period of time, so the reason we was amending these rules. And those were amended last summer. We had our fall conference, our statewide prosecutors conference in August, at which point in time he was expelled from our association, which was really the extent we could do. Based on the messages we saw at that point in time, we even thought it was appropriate. I can tell you that after reviewing the messages in totality of what you've sent us, nothing has changed my mind. And in fact, it's only gotten worse. One of the things that jumped out at me, other than some of the obvious that I was not aware of at the time, was a conversation he has with this young lady about another female who was a drug court participant. That the drug court participant was supposedly working at a adult entertainment industry, and the conversation was that, I don't know if I want to tell you because she's going to get kicked out of drug court. She'll be terminated from drug court and she'll have to go to jail. And his response was, I'm going to paraphrase, I'm not going to say anything. I want to go and watch. I want to go spend some money. That to me, as a prosecutor who has been involved in the drug court program in the Commonwealth of Kentucky since 2003, one of my earliest jobs as an assistant was the drug court prosecutor. And Laurel County's had one of the longest drug courts, I think the second or third longest drug court in the state. That to me spoke volumes that he was not interested in seeing a participant's success, but was interested in covering it up for his own gratification. That Brian spoke of one thing, and I just wanted to share that with you all. That really struck me as a drug court prosecutor, how wrong that is as the Commonwealth attorney who would be sending those people and know the conditions of probation and the conditions of drug court, just how wrong that is.
I would add that it's really, I can't express, I don't think in words, how baffling it is to all the Commonwealth attorneys in Kentucky that are out there doing the job and doing our best to do the job right, that anyone would engage in a romantic or sexual or otherwise personal relationship with anyone who's been through your court, much less someone who has active and open criminal cases anywhere in Kentucky, much less in the jurisdiction you're responsible for. It's just astounding. And this isn't about the three of us, or for that matter, the other 55, well, outside of us, 52 members of our association expecting prosecutors to be perfect people. This isn't about prosecutors not having sin or not having personal flaws, but whatever personal flaws a Commonwealth attorney has cannot be intertwined with a criminal defendant, because a criminal defendant is never on equal footing. It's never equal bargaining power, and it's bound to be coercive. And I think anyone who reads through these text messages can see the coercive nature of that relationship. And, you know, on the way to Frankfurt this morning, I was listening to talk radio, and they were talking about a suggestion that we start seeking donated organs, donated kidneys from prisoners, and how there was a major objection because it was unethical medical practices, because people who are incarcerated never are truly, I guess, in agreement. They're being coerced into the possibility of donating this kidney. And I think that's very comparable to this kind of situation, because anytime a prosecutor is either asking for or demanding or even suggesting to someone that they engage in a certain conduct when the prosecutor has the power to put that person in a cage, that's just, it's never a bargained for exchange. That is always going to be wrong. It's not fair. Quite frankly, we put corrections officers in prison for rape third degree or sexual abuse first degree. Anytime they have sexual relations with an inmate, no matter how willingly that inmate participated, it's still against the law for a corrections official to engage in that kind of conduct. And if it were up to me, we would include prosecutors, public defenders. We would include anyone who has that kind of coercive authority over a criminal defendant should be included, because it's just, it's reprehensible.
Well, thank you for those comments. Has anyone ever been expelled from the Commonwealth Attorneys Association before, to
No.
your knowledge?
As Jackie said, we had to amend our association's constitution because our original constitution did not allow for expulsion of members who embarrassed the rest of us. So I was the one that drafted the amended constitution to allow for this to happen, but that we can tell no one has ever been kicked out of the Kentucky Commonwealth Attorneys Association, because we didn't even have a constitution that allowed for it, unfortunately, until now, and we've had to expel two.
How effective do you gentlemen think someone can be as a Commonwealth attorney if they've been temporarily suspended from the practice of law? And what effect does that suspension have on their ability to effectively execute the duties of their office?
They can't. I mean, one of the requirements as Commonwealth attorneys is that you have to have a law license. And you've had it for 4 years. And when you take one of the requirements that you have a law license, you've passed the Kentucky bar, away, you cannot practice or be the Commonwealth attorney. We're not administrators. I guess would be the best way to put it. We just don't send people to court. I can tell you in Mr. Goldie's circuit, he don't have an army of attorneys that he sends to court. He's just making sure courts are covered. We don't have that luxury. I can tell you all three of us are in court a lot. I have court going on right now, but I have an assistant covering for me because I have some cases on that I took care of prior to now, but I would be in court otherwise. And if you don't have a law license, you cannot be in court. You cannot try cases. You cannot give legal advice to the law enforcement that are constantly calling us to make sure they're not messing something up or that they're getting it done the right way. So I don't think you can.
And that's the official legal answer, I think. But the practical answer is, even if you could, the lack of trust that your law enforcement and that your citizens are going to have in you, not to mention the fact, like right now, I think I think there's only one assistant currently working in the 21st Circuit. As long as he's in office, they're not going to get any more to come work there, because nobody wants to be associated with the stench that is in the 21st Circuit right now, and that will remain there until there is a new Commonwealth attorney that comes in and tries to reestablish credibility with the citizens. But then even if he were to ever get his law license back, I don't know how he ever goes through voir dire with a room full of voters who have obviously seen and heard about what's going on and what has happened, and he has no credibility with them whatsoever. That's, one of the reasons our office is so important, and the highest ethical standards is so important, is because the people that come into that courtroom place a lot of trust in what the Commonwealth Attorney says and what we represent and the witnesses that we call and the investigations that we bring into the courtroom. And if they can't trust you to be honest and forthright, then you're never going to prove anyone guilty beyond a reasonable doubt, no matter what the evidence is.
Well, and if it was a defense attorney, a public defender, a private attorney that didn't have a law license, they certainly couldn't represent their client in court. They couldn't stand in front of a judge and argue and be effective. There's just no confidence there. And the analogy is even more pronounced when it's a prosecutor, when it's the Commonwealth's attorney representing the Commonwealth of Kentucky, representing that jurisdiction, representing the victims, advising police officers. If his license to practice law is temporarily suspended, I don't see how any prosecutor without a law license could effectively represent in a legal capacity their jurisdiction, the Commonwealth, advise police officers, argue in front of judges. I just don't see how it could be done effectively for anybody.
I'm going to yield to some of our members who have questions. Representative Miles is recognized.
Thank you, Mr. Chairman. I guess for those of us that are not in your all's business and career, so to speak, can you put it in perspective a little bit more? Basically, what you have told is you've worked on your bylaws as far as kind of policing yourself, so to speak, a little bit as far as the expulsions and things like that. Is there what is the structure in place? What are the ramifications, I guess, for what you all are doing right now? Whenever you say expel, what does that limit and things like that? Because like right now, as far as what we're looking at, a lot of things come down to impeachment, whether or not the difference of what those recommendations may or may not be, and whether or not that person would be able to run for office again and things like that. So I guess as far as the law field as a whole, what is the structure in place to prevent these things from happening going forward?
There's very limited recourse against a Commonwealth attorney. There are 57 judicial circuits in Kentucky. Obviously, we have 120 counties, so some Commonwealth attorneys are responsible for more than one county. The Commonwealth attorneys do not report, contrary to what many in the public believe or assume, we don't report to anyone except the folks that elected us. So we don't have to answer to the Attorney General. We don't have to answer to the governor. The only people that we do have to answer to is the Prosecutor's Advisory Council. The Prosecutor's Advisory Council is 5 Commonwealth attorneys, 5 county attorneys, 2 citizen members, and the Attorney General. The Prosecutor's Advisory Council has control over every prosecutor's office's budget in Kentucky. That's all the Commonwealth attorneys and all the county attorneys. And that's it. We can't suspend people, we can't discipline people, we can't censure people. We haven't been given that authority. The only thing we have been given the authority to do is set policies, which mostly are budgetary, and then set the budget. So the Prosecutor's Advisory Council's recourse against any individual Commonwealth attorney, we can't even suspend their salary. Now, in Mr. Goldie's case, the Prosecutor's Advisory Council voted that if he didn't voluntarily give it up, that we were going to, in essence, sue him to recoup the salary from the day his law license is suspended, arguing that he has effectively vacated his office because he's not doing the work. That and he since then has agreed to forego his salary effective yesterday if we didn't seek the back salary from the day that he was suspended. Other than that, our only other recourse against him or against any other Commonwealth attorney is what we refer to as the nuclear option, and that's zeroing out their budget. However, that in and of itself wouldn't stop the Commonwealth attorney's salary. It would only stop the salaries of everybody else that works in that office, the secretaries, detectives, victim advocates, any other prosecutors. That effectively shuts down the criminal justice system in any circuit if you do that, because it leaves one person, in this case, the one person would have a suspended law license, so they couldn't come to court. It really wasn't a good option for the citizens of the 21st Circuit, and he's got multiple counties that are counting on his office to keep the justice system up and running. The Kentucky Commonwealth Attorneys Association was comprised of the 57 Commonwealth attorneys until we had to expel 2. So now obviously we only have 55. We are a more or less a social organization, a lobbying organization to some extent. We try and express to all of you what we think is good policy or what we think is bad policy in order to help you effectively legislate. However, other than that, we put on training. When we expel them, it's mostly symbolic because we want the citizens of Kentucky, the legislature, the governor, everybody to know what we think about their misconduct. But it really doesn't, the Commonwealth Attorneys Association has no disciplinary authority whatsoever. It is strictly symbolic. The biggest punishment we have is he's not allowed to come to our convention. That's it. We meet once a year, so he misses out on one 3-day trip to Lexington. That's all we can do.
If I may follow up also.
Yes, go ahead.
As part of the PAC, we do set the budget. The reason we can't, and I've had this asked, the reason we can't suspend his pay because he's a constitutional officer. So that's why there has to be an impeachment of him. PAC can't stop his salary. There has to be actually an impeachment to stop that, or he agrees not to pay it. So it's actually a 3-phase, in this case it would be 3-phase, from the association to the suspension of the salary by agreement of him, and then the impeachment is the only way to get him out of the office. I do want to mention one thing you said. Impeachment may hinder his further ability to run for office. The funny thing, it's not funny, but the thing that you got to remember, if the election was today, the filing was today to run for Commonwealth attorney, he's not qualified to run. He does not have a law license. So he couldn't even come to the Secretary of State and file his paperwork to run for the office of which he's holding because he's not qualified. Just want to follow up on that.
Thank you.
Representative Decker, you're recognized. Was answered, okay. Representative Kulkarni, you're recognized.
Thank you, Chairman, and thank you, gentlemen, for your comments and explanations. I have a question kind of piggybacking on what
You have-
Representative...
Staff's telling me microphone.
Oh, sorry. It's on.
Yeah.
Is this better?
That's
Okay.
that's-
I wanted to piggyback a little bit on what Representative Miles was asking you in terms of impeachment, and you mentioned his law license and he's not qualified, not eligible for anything right now. In 5 years, the suspension is up in 5 years. Is that
The suspension is
of his law
It's
license?
just temporary right now.
temporary right now. So there's been a recommendation, is that right?
I think there's a recommendation for
Yeah.
a 5-year suspension, and then
I
my
think
understanding is he would apply for reinstatement. He could apply for reinstatement. I think it's still up to the Bar Association.
If I can read from the Supreme Court order under paragraph 3, I found this very telling in regards to what the Supreme Court thought of the conduct. It says disciplinary proceedings against Mr. Golden may be initiated by the Inquiry Commission pursuant to Supreme Court Rule 3.16, unless they've already begun, which they had, or, and this is the important part, Goldie resigns under terms of disbarment. That is not temporary. That's not for a 60 months. That is a disbarment. That is a complete disbarment. You're not practicing law in Commonwealth Kentucky.
So if he's not disbarred and it is just, let's say, a 5-year suspension, there is a moral character factor when evaluating whether a person is sort of has the fitness to practice law in Kentucky. In that, if the suspension is over and he reapplies for his law license, would that come into play, or is that something that, because he previously held a license, would not be as much of a factor?
If you're suspended for more than 6 months, it's the KBA's rules, the Kentucky Bar Association's rules, that you have to go back through the character and fitness process that every bar applicant goes through the first time you apply for a law license. So even if his suspension were up, he would still have to pass character and fitness tests in order to get his law license back.
Okay, and just assuming that he does, I'm sorry, Mr. Chairman, quick follow-up.
No, go ahead.
Assuming that he does, there's nothing that the advisory council or anybody could do if he runs for a Commonwealth Attorney
Be up to
position
the
again?
voters
It
of
would be
that
up to the
circuit.
voters.
Be up to
Okay,
the voters of the 21st Circuit.
okay, thank you.
Thank you. Representative Nemus, you're recognized. Come over closer to me.
This one's working. Thank you, Mr. Chairman. Thank you, gentlemen, for coming. Appreciate the work that you do on behalf of our constituents, on behalf of our citizens of Kentucky across the Commonwealth. Reading Section 100 of our Constitution, I think there's an argument to be made that he couldn't run if he filed today. I would take the other position, which makes it more urgent that we do move forward. I think because all he has to do is be licensed. If you're suspended, you're still licensed. You can't go into court and practice law, but you do still have your license. So I don't know how court would resolve it, but I don't think that issue is resolved. And so let me ask this question. You know the conduct that is alleged here against this gentleman. Do you believe that it's sufficient in nature such that we should move forward in prohibiting him if we move forward and impeach and remove? But should we add the prohibition that he run for office again in the future, that he cannot run for office again in the future? Do you think this conduct rises to that level?
I do. I mean, I don't know if you're allowed to prohibit somebody from only running for a certain office, but I certainly don't think he should ever be Commonwealth Attorney again. And I can't stress to you enough that I don't take this impeachment lightly, nor do I take publicly condemning another Commonwealth Attorney lightly. I don't think any of us do. In fact, I don't think anyone in the Commonwealth Attorneys Association took it lightly when we expelled him from our association. But from what I've observed, no, he just can't be trusted with this most trustworthy position. And if that means that we have to ban him from running for coroner or constable or any other office, then so be it, because it's that important.
You other gentlemen agree?
Well, I definitely don't disagree with that. And you know, the issue that I have, and of course we're operating under the assumption that all of this is accurate at face value for what we've seen. But the issue that I think we all have, and I think all the Commonwealth attorneys have, is that there's so much, and Jackie and Mr. Sanders have alluded to this, there's so much of what we do every day that is left to the prosecutor's discretion. You know, there's a lot, you all know the statutes that are on the books that require certain things, but when it comes to sentencing recommendations, positions on probation, decisions to revoke or void pretrial diversion or probation, referrals to drug court, so much of that falls within our discretion that we have to exercise judicially and appropriately. And what I saw, and when I got these messages, after Chairman Elliott shared this with us, or the committee did, it just showed a complete, if true, lack of appropriate discretion in decisions, in requests, in statements, in use of his office, use of his position. If true, it seems to me that there's an extremely compromised exercise of his discretion, which doesn't lend itself to just being rehabilitated or cured or changed in the future. So I agree, but for me, it's because of the issues that I see with his actions of discretion or lack thereof in these messages. If all of them are true at face value, which I accept them as they are, as presented to me from the committee.
Mr. Steele?
I would agree with Mr. Sanders. I'll step a little farther than my colleague Mr. Wright did, and I would. This is egregious. From the position we're in and the trust the community and the citizens give us, the actions of what he's done, and things he's done that we saw in the messages, they're egregious to the point that I do not think. I think that should be a portion of the impeachment, not to run for prosecutor.
I agree with that.
And Brian's being very fair in saying if
Yes.
true, but I would also point out that a lot of my opinion is not only based upon what's in the messages, but it is based upon his explanations or lack thereof in front of the Kentucky Bar Association's hearing on whether or not he should be temporarily suspended. That the three of us routinely prosecute variety of offenses where suspects are being interrogated and they try and tap dance around not lying by saying, well, I don't remember committing the crime. And some of these crimes that these folks have been accused of, whether it's child molesting or murder or rape or what have you, horrible offenses, and their answer is, well, I don't remember, or I'm not sure, or these didn't come off my phone. You know, those kinds of answers are the kind of answers that the three of us would most probably look at that suspect and go, oh yeah, he did it. Because, you know, you accuse me of something like this, I'm going to be able to tell you real fast whether it's true or not true. Because this isn't the kind of thing that I don't recall is an appropriate answer for.
And let me say, too, in the response to this body that I read from Mr. Goldie, there's clearly an acknowledgement of some relationship between him and the female defendant. There's an acknowledgement of giving her money, which I find disturbing. There's an attempt to shift that these weren't requests for nude or naked images because those two specific words weren't used. And to me, when you read the messages in the entirety, the context makes that a very disingenuous response and seems to be avoiding the obvious by just saying, well, I didn't use two words. So, you know, even the response to me shows a lack of appropriate decision and discretion.
Following up in regards to what Rob said, I'll give you one example when I read his response. One example of what Rob's talking about as we read these and what we typically read through. And the pages of his are not numbered of his response, but it's highlighted June 5th, 2018, images 12 through 13. It says, for example, he asked, when do I get to see a video? When she replied, when do I not have a warrant? Ha, ha, ha. His response to this committee, or whoever he sent it to, was no such messages on June 5th, 2018. Those messages' response was actually on June 15th. So he is correct. It did not occur on June 5th. Now, whether that was a typo or somebody omitted a one, that's what he just said. No such messages occurred. He didn't try to explain the message. No, that didn't happen on the 5th. It did not happen on the 15th. Those are the things. One of the examples I'm telling you that as we read these, we see the inconsistencies or the tap dancing around the issue instead of answering the issues or answering the questions.
Representative Decker, you're recognized.
I want to thank you all for your testimony today and for the fact that, I mean, we are at a time where trust in public officials at all and institutions is at an all-time low. And I appreciate, as an attorney, and as an attorney who believes in our judicial system, that you are policing your own. That is impressive, and I thank you for it. One of the things you have said, and it's quite fair to say, if these are real, they were produced by Mr. Goldie. It's much of it, if not all of it. So my thought is, I wanted to go back to what you said about the disbarment. I somehow missed the context of that. Could you say that again?
We've said disbarment a few times. Do you know what I was?
You were reading from, I think, a recommendation.
Oh, that's in the Supreme Court recommendation.
Okay. And
the Supreme Court order adopting the report of the special commission where they
Yes.
had a hearing and there was
Yes.
testimony and temporarily suspending him. It basically says under paragraph 3 that disciplinary proceedings against Goldie may be initiated by the inquiry, which is it's part of the requirement under the KBA commission pursuant to Supreme Court Rule 3.16, unless they've already begun, or Goldie resigns under terms of disbarment.
Okay.
Now, typically what we'll see, and correct me if I'm wrong, but you'll see unless there has been an agreement otherwise, or the parties have reached an agreement as to that. And it could be anything from a public reprimand, a private reprimand, a 30-day suspension. They don't give that option of reaching a resolution other than terms of disbarment. I thought that was very telling when I read that Supreme Court order.
So my question is around that. What if he doesn't resign with terms of disbarment? Then they will go forward. So my question is, if they don't disbar, is that some indication that they don't think it's of such an egregious nature that he should never come back? In other words, if they suspend it to come back after 5 years, what we're thinking of and considering is never coming back, never being able to come back as a
Elected
public
official.
official. But would we take anything less than disbarment as they didn't feel that it was that egregious?
I don't think it would be a fair comparison
Okay.
because of the bodies, their different purpose in
Yes.
regards to what this body's purpose would be for an impeachment and what that body's or inquiry commission would be for suspension of a license or disbarment.
It's a
I think
different-
it's completely different standard that they would be looking at.
Thank you. That was my question. Thank you.
Thank you. Does any other member have Representative Miles?
Thank you, Mr. Chairman. And this is something that we thought was a little bit, I won't say we, this is something that I thought was a little bit unusual, and you all have kind of danced around it a little bit. I thought it was odd that the evidence used against him and the evidence that we've been provided, allegedly, if accurate, was the same defense that he used. So the evidence against him was the same evidence he provided us as his defense. Is that?
Can I ask one point of clarification? Representative Decker, you indicated that all these messages were produced by Mr. Goldie. I want to make sure that I'm on the same page. There was 125 printed pages of what appear to be, I think it's Facebook Messenger exchanges between him and another lady. Did Mr. Goldie, he's the one that produced all 125 pages?
I can clarify that,
Okay.
Mr. Wright. You received all of the messages that we have in the record based upon what the
125
inquiry
pages, yes.
what the inquiry commission reviewed and the special commissioner or so you had all the messages. His response did in fact include some of those messages, but you received all of the messages.
Okay.
Just to clarify.
And I don't think I received, so I received his response, but not the specific attachments that he included. It appeared to reference the same ones. So, yeah, I mean, I think he's just attempting, from what I see, to somehow explain his conduct, and the conduct is just simply inexcusable.
That was the main question. Did you see anything that justified any of the evidence that he provided as a response?
No.
For anything that would have possibly ever been considered within ethical of practicing
I didn't.
in his position?
No, and criminal defendants have a right to remain silent. I think Mr. Goldie probably could have asserted his right to remain silent. However, when anybody waives their right to remain silent, you're allowed to judge the plausibility of what they're saying. You're allowed to determine the credibility of the witness, and if that witness happens to be the defendant, or in this case, the subject of the impeachment, you're allowed to make determinations about what he says. And if his explanation is just not plausible, well, I think it's well within every member of this commission's authority, responsibility to look at what he says, determine whether that's a plausible explanation for his conduct. Now, it would be well, I shouldn't say a whole different situation. I'd still have a lot of questions because I think that what's in the text messages corroborates the testimony given at the bar council hearing that the woman who's involved in this, it gives a lot of credibility to what she said. It corroborates a lot of what she said if he had remained silent. But once he starts explaining, his explanations just are not good. And that's really what is sort of the icing on the cake for me.
I made a couple of notes. Jackie talked about the drug court issue, and that's a problem. But once she asked, when am I not going to have a warrant? And his reply is, incentives never hurt. Well, that's, to me, that's as unethical as it gets to ask a defendant for some, and then he follows it up with asking for this video again that I think everybody on the committee is familiar with. I mean, he's clearly asking for something from her in exchange for using his discretion, his position of authority, and the trust that presumably a court has in him to go and ask that court to withdraw a warrant for her arrest. I mean, that's a weighty issue. I mean, that's something that when you go to a judge, number one, likely ex parteing the judge to ask for a warrant to be recalled, and then you return to the defendant, and then he follows it up 2 pages later, you owe me big time, and when she asks why, because judge is about to withdraw some warrants. That just seems to follow up the exact quid pro quo, if you will, of using his position of authority for some benefit or at least some demand on this defendant that prosecutors just can't do. I mean, it's clearly wrong.
I mean, if he was asking for money instead of a video, I'm pretty sure everybody here would agree that that is blatantly unethical and probably against the law, definitely against the law. So how is a video that is compromising, to say the least, something that obviously she was hesitant, did not want to provide, yet he kept asking for it, how is that any less unethical than demanding or requesting U.S. currency?
I think, and just to follow up on Mr. Wright, I think when he read that, his response, I think there's one word that I circled, I'm not sure how many times through here, one word, 3 letters is owe. You owe me, which that's his words. That's what he chose, owe, and we all know what the word you owe me means. I've given you something, you owe me something back. That word alone, when I read that, and that was in the first 40 pages, I went, holy moly, this is crazy. And the fact that he sends this as his defense, and in all honesty, we've all dealt with those defendants who don't think they've done nothing wrong. And I think that goes towards the not running for further office issue that you all have to look at. He still refuses to understand that he has done anything wrong and tries to defend it with words that obviously shows what he's doing was wrong. So I just want to follow up on that.
May I ask one more follow-up?
Yes, you may.
And this is in a different category, but as far as the communication of him basically representing her and not being her attorney, so to speak, that his position, but yet acting as her attorney, I guess, or acting as a good friend or whatever it may be. Does that happen? I mean, is that something that's common? Is that ever a correct category?
I think the best way I can answer that is there have been times where I may go into court and say, Judge, this defendant is asking you for probation, and yes, they have been working, they've demonstrated, you may speak up on their behalf. But being an advocate the way he was for her, I think you were struggling with the word, was he representing her? Was he advising her? He was certainly advocating for her. That's just improper. It's unheard of to advocate outside of the court. It seemed to me that he was acting as a liaison between her and the prosecutor. There was a special prosecutor in that case, that appeared to be, and her attorney. He was actually taking the place of her attorney, which is unethical to have that type of conversation with a represented defendant that has counsel. That communication should have gone through the counsel if he was involved at all. And once he asked for a special prosecutor, and I don't know the circumstances, but clearly he asked for a special prosecutor. Once he did that, he's out of that case, and he shouldn't be interjecting himself into representing her, advocating for her, going behind the court's back to try to get something done. That should be left to her attorney and the counsel involved in that case. I don't know if that answers the question. But.
It does.
At the same time, I think it's also clear from the Kentucky Bar Association's findings that the request for the special prosecutor didn't come until state police observed text messages from Mr. Goldie on the defendant's phone And so the police knew that he was having personal communications with one of his criminal defendants. Only then was a special prosecutor requested. So anytime I am close enough to a defendant or know a defendant well enough that anybody could accuse me of doing them favors, that's when I request a special prosecutor. Not once somebody finds out about it. It's at the front end. And I don't have communications with any defendants more than maybe a nod acknowledging them, like hello or goodbye if you pass on the elevator or something. That's about it. And I think I'm sure, and especially the smaller jurisdictions, I'm sure, you get in parts of Kentucky where everybody knows everybody, and it's a little bit different, but you should never be talking about a defendant's case with a defendant directly without their attorney being a party to the communications. That just should not happen, period.
Thank you.
The issue in regards to the card, the issue also is I can tell you, me and Brian talked about, we're in a much more rural jurisdiction, and it's not uncommon for us to get a phone call from a defendant. Now, 90% of the time, we know the name, or our office staff know the name, and they say, you got to talk to your attorney. Call your attorney, call your attorney. If they get through to us, we get a Facebook message, we ignore it, or we call your attorney. The issue with the car was a big issue we dealt with about 5 or 6 years ago, maybe 7 years ago now, in which the storage units, and I can tell you the background, the storage units were charging the defendants to store their vehicle while the prosecution was ongoing. Well, the possession of a drug case may be ongoing for 8 or 9 months, and they were charging $25 a day. It's a $2,000 car. They're wanting $8,000 in storage fees. So there is some case law, and Mr. Goldie actually gave her the case law and those type things. When I've had those come up before, after a case is resolved, after there's no more representation, they're not represented by an attorney, and my response is still, you need to contact your attorney. They can file a motion, and I'll agree to it. I don't have a problem with it. And that's the extent of my representation to them, that I'm going to do anything else. I'm not going to do, I'm agreeable to it, but your attorney has to be the one to file the motion. That's the appropriate way to handle those things. You don't advocate for them. You don't do case law research for them. You don't contact the person holding the unit for them. You don't contact the judge to try to get orders entered. That was just wrong.
Thank you.
Thank you. Representative Burke, you're recognized.
Thank you, Mr. Chairman, and thank you, gentlemen, for coming to speak to the committee. I wish to take what you've discussed over the last few answers and combine that then with the charge of this committee. We have to decide whether or not we will issue articles of impeachment against Mr. Goldie. When it comes to issuing articles of impeachment, KRS 62035 says that we shall state with reasonable certainty that a misdemeanor in office for which impeachment is sought, what that is, that there's at least one of them, and that it shall be stated separately and distinctly. Now, misdemeanor here is defined differently than it is in criminal statutes. Would you say, based on the quid pro quo communications, based on the representations of ex parte communications relating to legal advice to someone who's represented, and other conduct, that there's at least one misdemeanor, so to speak, for which an article of impeachment could be issued, or that perhaps there's more than one?
I think there's more than one. I think official misconduct fits, and misdemeanors, and trust me, I've thought a lot about whether or not any of these would rise to the level of felony offense because of the dual prosecution system we have in Kentucky. Obviously, I spend a lot more time looking at felonies, and I know the felony system and what we do if we can find a applicable felony here, versus if it's only misdemeanor offenses, then it's not within the Commonwealth attorney's jurisdiction, and it has to be a county attorney that takes action. So I haven't taken the time to peruse all the misdemeanors to see if I can find more, but I'm quite certain that official misconduct would be at the very least appropriate, and quite frankly, I think it's probably a good impetus for the legislature to look at the possibility of expanding some other laws to keep something like this from ever happening again.
I would concur with Rob on that.
I think what Rob's talking about to expand the law would, one of the things that the phrase we deal with a lot is pecuniary interest. And was he getting something of a financial or pecuniary interest? And that's something I think needs to be broadened to include the types of photographs, videos that he was demanding, receiving, asking for, requesting. I don't know that in state court it particularly fits, but I think it should, if that makes sense.
Yes, you may. Go ahead.
I appreciate that very much, and wish to clarify that the misdemeanors that we are charged with are different than the statutory misdemeanors that a county attorney would handle. So just to clarify that point, do you believe that there's enough misconduct here, that there are several different acts that could be separately defined if we were to issue articles of impeachment?
My opinion is the short answer is yes. And the reason I say that, there's a number of different aspects of this that are so wrong that I think it warrants impeachment. But if not now, then when would you ever impeach a Commonwealth attorney? I mean, short of killing someone or committing some other, violent physical offense, as far as ethics go, this is about as unethical as it gets. And it's no different. In fact, it might be worse than taking cash from a defendant. And we would all agree that that was highly inappropriate and worthy of impeachment. So if taking cash bribes is worthy of impeachment, wouldn't this be as well?
And I think the answer of the pecuniary interest that Rob was talking about, I think it's found also in his messages where he's talking to her about he had a friend who was selling these type things. And I think there's where you show the pecuniary interest. There's some value to those. But again, I agree with Rob, and I believe that, yes, if not now, when?
Thank you.
Thank you, gentlemen. Thank you for your question. Representative Decker, I think you had a follow-up.
I did, and I think I failed to ask the question I really was getting at. Is, let's say that the Kentucky Bar Association does not disbar, he doesn't resign in that way. Is it your opinion, and I think the answer has been said in different ways, but that regardless of what they think about him coming back to practice law, if we there are grounds, in your opinion, that we should say that he should not hold the public trust again in public office, regardless of that proceeding?
Yes.
Thank you.
I think the answer easily is yes. And let me kind of make a distinction here. The Bar Association talks about whether he can practice law, whether he can get out here and be an attorney, have people retain him to do legal work for him. This body, and what we're here for, is whether he is fit to hold the position of Commonwealth's attorney. And I don't want to speak too much out of turn, but that's a position that all of us hold very near and dear to our hearts. We have a lot of pride in the Commonwealth's attorneys across the state, and specifically the position of Commonwealth's attorney. It's not personal to any of us. It's a position that we are fortunate enough to be able to hold, but we hold it in a high regard. And we believe, or I do, I think they all do, believes that the public holds the position of Commonwealth's attorney in a high regard, separate and distinct from our position as a practicing lawyer. I think because of the work that we do, the responsibility we take on, we have a tremendous sense of pride in that office, in that position. And it's a job that we go to work and do every day because of the pride that we have in that position, not just as a practicing attorney, but as the felony elected prosecutor for our jurisdiction. And that's why, it's not easy to come up here and say that, hey, one of our fellow prosecutors, a brother or sister in our 57 fraternities of Commonwealth's attorneys, brotherhood or sisterhood, is not fit to do that. But we believe, because of the position of Commonwealth's attorney and what all it entails, that impeachment would be warranted in this case because of his conduct.
Thank you. Does any other member have any comments or questions? I had one final question, and then we'll allow you gentlemen to close. How unusual is it for a Commonwealth attorney to go outside of their circuit to advocate for a defendant who is in their circuit How unusual is that? Is that unprecedented in your mind that a Commonwealth attorney would contact another county? I think in this case it was Clark County, to try to intervene in that individual's case.
To this degree,
In this context, yes. Now, I will say that, in my jurisdiction, I have common defendants with a lot of other jurisdictions, say Russell County or Pulaski
Right.
County or Taylor County. A lot of folks from Casey and Adair that end up with charges in my jurisdiction in the 29th Circuit will also have charges in the 11th or the 40th or the 28th. And I may contact the prosecutor over there and say, hey, what are you doing with this case? Or this defendant is doing well over here or not doing well. I have them on bond, you have them on probation. We may share information, so that's not uncommon. It's not uncommon for us to be designated as a special prosecutor in another jurisdiction. But in this context, advocating outside of the context of what you would perceive as the prosecutorial responsibilities, yes, I think that is unusual, and I don't want to say unprecedented, but it's close to being unprecedented in my mind, if that answers your question.
I would echo what Brian just said, in that we do talk to Commonwealth attorneys about charges they've got, but I can only remember, and I may be wrong, I can only remember one time I was called by a Commonwealth attorney and said, hey, you've got a warrant on somebody, can you get it recalled? And it was because he had a murder trial going, and this individual was a witness traveling from another state and was afraid it was going to get pulled. And so I actually looked, it wasn't my warrant, it was a district court warrant out of our county attorney's office, and I called the county attorney and got him on board. Ronnie Bowling was the Commonwealth attorney who needed this witness coming out of Texas and was afraid they were going to get picked up on somewhere on a Greyhound bus, as they got him a Greyhound bus coming up, and would delay his trial. That's the extent of which we worked to get a warrant recalled so that a witness could come testify in a murder case. As Brian said, the context of this is completely different than that. And although what is calling other prosecutors and asking, as he said, happens, never in this context. Now, I want to make sure you understand it's never in this context.
Well, thank you, gentlemen, very much. I'd allow you to have any closing comments that you would like to make.
I sort of used my closing comment already, because I was going to, my if not now, when comment was going to be what I intended to close with. But I would just indicate to this committee that I think that when we voted to expel Mr. Goldie from our association, the gravity of that vote that our association took, I think that was our impeachment right there. We were just handicapped by the fact that all we could do is take symbolic action, and it's unfortunate that I have to now suggest to the legislature that maybe we need to look at giving the Prosecutors Advisory Council a little more disciplinary authority to try and prevent things like this from happening in the future. Maybe we wouldn't have to have hearings like this, but nevertheless, we are where we are, and I would just, again, stress that none of us want to be in this situation. None of us want to have to come testify in a situation like this, but most importantly, none of us want this kind of a situation to go on in the Commonwealth of Kentucky, and that's why we're here, and that's why we are highlighting the actions our association's already taken, and the actions the Prosecutors Advisory Council has already taken, and encourage you to move forward with the impeachment that's been entrusted to this committee. Thank you.
In closing, I'd say I appreciate the opportunity to be here, and I agree with Rob. It's tough. It's a tough decision for this body to make. I understand that. Impeachment is a drastic measure that should only be reserved for very, very limited cases. We believe the conduct in this case rises to that level, and it's tough. It is. And when I saw these, when Representative Elliott first contacted me, it's a tough ask to come up here and say, to testify before this body as to why one of our fellow Commonwealth attorneys' conduct is that egregious. But from what I knew beforehand, I felt like it was, and then these additional messages, the full context of them that I received in preparation for this, it's clear that the conduct is that egregious. And again, I appreciate your all's consideration of the matter.
Yes, thank you all for having us up here today, and we do understand the gravity of the decisions you all have to make, and we appreciate that. And Brian's right. When he contacted me and Rob about coming to testify, I can tell you we all three had our hesitation. We all had that moment of, man, that, you know, do we want to, and then, like Rob said, if this doesn't reach that level, what does? And as Brian said, the respect that we have for not only our citizens in our circuits, but for the citizens of the Commonwealth and all the other circuits. And we think they're all entitled, or should be entitled, to fair representation by a Commonwealth attorney who is not conducting himself in this manner and is conducting himself above reproach. That's why we're here, and we appreciate you all having us listening. Thank you.
Well, thank you to each of you, and we really appreciate your time and your willingness to come and testify. We know it's not easy, as each of you have pointed out. We thank you for the great job that you're doing. You're a great example of Commonwealth's attorneys across Kentucky, and you're working along with law enforcement to keep us all safe, and we appreciate that very much. And we thank you for the powerful testimony that you've given this morning. Is there a motion to go into executive session? We're in executive session.